Good afternoon, and thank you all for being here. I have the honor and the privilege to moderate this panel. So I am going to hopefully present you with some intimate information and sort of a peek behind the curtain, if you will. So I'll be asking our judges questions, and hopefully they will give us some candid answers. Just for anyone who doesn't know who we have Judge Lewis, who is our longest member of the bench, who was appointed on 2001, and then Judge Roberts in 2007. All the way at the end is Judge Ray, who was appointed in 2011. We have Judge Thomas, Kem Thomas, not BL Thomas, in 2016. And on the other table as well, Judge Nordby, who is our newest member in 2019. So the way we'd like to start this afternoon is I'd like each of the judges to kind of give us a brief introduction of how your journey from pre-judge days to being on the bench. Starting with Judge Lewis, can you tell us a little bit of what it was like before you were a judge?
I'm sure most of you have seen my resume, Avita. Of course, out of law school, my first job was as a law clerk for the Industrial Relations Commission. I'm probably dating myself by saying that. But as you know, the RSC heard all of the appeals from the JCCs, and from there they went directly to the Supreme Court. After that, I went to the PD's office, started out in juveniles, then misdemeanors, then felonies. At that point, I thought I needed a little bit of civil jury trial experience as well. So I went to the AG's office in a newly created tort section where I handled claims filed against the state and state agencies pursuant to 768.28 Florida statutes, which is, of course, is the state's limited waiver of sovereign immunity. Also, since I was the only attorney in that branch who had prior workers' comp experience, also represented state and state agencies and workers' comp claims filed by state employees. From there, I went to my state programs branch. And those of you who are familiar with the Attorney General's office know the state program branch handled civil rights claims filed against state employees pursuant to Section 1983 and 85, as well as I defended the constitutionality of state statutes, handled dependency appeals, and also constitutional challenges to state statutes, as I said beforehand. From there, of course, I went to the employment branch, where I headed up the employment branch of the office. There I defended claims filed against state agencies pursuant to Chapter 760, which I call the little Title VII, as well as other employment claims, Title VII claims, EPA claims, ADA claims, ADA claims, as well as FLOSSA claims as well. So the gamut of employment issues I handled there. And from there, I was appointed to the bench, to the First DCA. When I was appointed to the bench, of course, as I said before, and I previously worked at the PD's office, at that time, the late Judge Michael Allen was the public defender for the Second Judicial Circuit. So he was my employer before he ascended to the First DCA, as well as the late Judge Charlie Manor, who was a judge on the First DCA. But before he was appointed to the DCA, he was a trial court judge on the Second Judicial Circuit, and when he served in the criminal division, I also practiced before him. So my point is, both those judges kind of took me under their wings when I ascended to the First DCA and kind of showed me the ropes and served as mentors for me, and that's my journey. Of course, since I was a generalist in terms of my practice, it helped me here on the court as a judge because I handled both civil as well as criminal matters. And criminal, of course, constant majority of our cases. So I was experiencing in handling those cases, and I did make the transition from being an advocate to one who advocated for certain issues to one who made the decision on those issues, which was fairly simple. With the, of course, with my mentors serving as a resource aid for me as well.
Judge Roberts, how about you? What was your journey to the bench like?
Yeah, I was an election lawyer in the Florida Senate and the Florida House of Representatives, and helped write election bills there. And I became director of the Florida Division of Elections, and I did that from 1999 to 2002. And nothing was going on during that time where I was director of elections. After that, I became general counsel at the Department of State and you know, had arguments in the Supreme Court and you know, litigated all kinds of issues on behalf of the Secretary of State. And then I became executive deputy and then deputy attorney general of the state of Florida. And from there, I was appointed to First DCA.
Okay, great. Judge Ray, how about you? Can you give us some insight into your journey?
Absolutely. And one of the things I love in just hearing my colleagues talk about their experiences is how different each of our stories are. And I love that there's just not one pathway to the appellate bench. So my pathway was different than the ones that you've heard about already. I started out in a traditional legal role. I worked with the law firm of Owsley McMullen here in town, and at the time I think I was the only associate for several years, and so I did everything including taking out the trash. It seems like, no, they didn't ask me to do that, but in all seriousness, I got exposure to all kinds of different areas of the law. I did DOA proceedings, I did appeals, I did civil litigation, I even did some transactional work. So it was just wonderful, and of course working for some of the finest attorneys in the state of Florida. During that time, I stayed very engaged with the law school, FSU College of Law, which is my alma mater, and when they had an opportunity, I took it. And for a period of time, I worked at the law school and senior level positions as the Associate Dean for Academic Affairs and Administration. And if you think of a law school like a business that has legal and non-legal issues come up, that's kind of what I did. I helped with running a business. And there was never a dull moment, but it was really exciting to be a part of academia. As much as I enjoyed that, I did yearn to get back to a more traditional lawyer-type role. So when there was an opening at the Public Employee Relations Commission, I applied for it. Governor Charlie Crist appointed me to the position as chair. So in that capacity, I both ran the agency, you know, appearing at the Capitol, asking for money, doing all those things you do when you run an agency, but I also served in a quasi-judicial role as a commissioner, reviewing the hearing officers' proposals for, you know, competent substantial evidence for their findings of fact and reviewing their legal conclusions de novo, kind of acting as an appellate judge in that respect. And so I really enjoyed kind of being a judge. I enjoyed being it was a quasi-judicial role, but it was a role that enabled me to try to figure out how to put all the pieces of the puzzle together in a neutral way and then have to justify my reasoning in writing, which is always the hard part, right, sometimes. So I enjoyed that. I got a lot of fulfillment out of that. I was challenged by it and excited by it. So when an opportunity came open at the First District Court of Appeal, I applied and was blessed. The stars aligned, and Governor Rick Scott appointed me in 2011.
Very nice.
Yeah.
Wonderful. Judge Thomas.
Well, mine's short and sweet. You're living what I do, so I don't have to explain that at all. But I guess it was 25 years I had done it, and there was an opening on the First DCA that I saw, and I just laughed and thought, you know, I should probably put my money where my mouth is because I'm always complaining about the First DCA and like, what are you people doing? And, you know, you're messing up comp and you're not giving us enough facts and, you know, all that. So I thought, well, I'll at least apply so I can get rejected and then I can say with, you know, at least some humility that I tried. So went through the process, never thought I would get past the first round and just went into it thinking I'm just going to enjoy this experience and meeting new people. In fact, Clay, I had memory. You let me in the front doors. It was a Saturday morning. Clay was the chief, and they had the first round of interviews here. So I remember, you know, sort of shaking and sitting out in that vestibule thinking, you know, I'm just going to have a good time with this and enjoy it. And I can't, you know, believe it that, you know, here I am. So I certainly hope I represent all of you well.
Very nice. And you do. And last but certainly not least, Judge Nordby, can you tell us what it's been like for you and your path to the bench?
Yeah, so my legal career actually began right after law school at the First District Court of Appeal. I graduated and almost literally walked across the street to the old First DCA building and began clerking for Judge Brad Thomas right out of law school. And I did that for about a year and a half, and then I was expecting my first child, and I made the decision to take a break from practice and stay home and raise kids for a few years. But I always knew at that point I want to get back and practice law eventually. Just these first few years of being a parent, I just really want to stay home and figure things out as a parent. So a few years passed, had a couple kids, and then an amazing opportunity opened up at the Solicitor General's office at the Attorney General's office. This SG's office, we call it SG's office, is a specialized unit that was created to handle significant or high profile or tricky or complex appeals in which the state of Florida has an interest. And the SG at that time was Scott Makar, and I had taken some classes with him in law school, and as luck would have it, an opening unexpectedly opened up. I applied and worked there for almost 7 very full and busy years. It was just an amazing place to work with amazing people. I worked under Scott Makar, Tim Osterhaus was SG for a period, Alan Windsor, Amit Agarwal, and just had an amazing time there. But another wonderful opportunity opened up at a private law firm, Schutz & Bowen, and so I went over there and was an appellate practitioner before an opening came up here at the First, and I applied, and lightning struck, and I'm just really happy to be here.
We're happy to have you. Thank you. So, Judge Lewis, you have been on the bench the longest of this panel. And I'm
I don't
sure,
think I'm the senior judge.
On the court.
I'm sure you've seen a lot of things in the past almost 20, well, over 20 years. What are some things that you've seen? What are some of the biggest changes that you've seen in the appellate world since you've been on the bench?
There have been a number of big changes on the court since I was appointed. You know, when I first appointed, everything was filed in paper. Briefs and the record were all via paper. And I can remember times when I have volumes of the record stacked up in my office while working on a case. Now everything is filed electronically. We even vote electronically. Our DCA and CFAC has made a big difference in our work. I think it's made us a more efficient court. Even when we conference cases, we ultimately vote on cases. The law clerk summaries are all uploaded. We review them online as well. So, as I said beforehand, I think electronics have made us operate a more efficient court. The only issue I see is it can be hard on the eyes at times. Also, we created the workers' comp unit, which was created specifically to handle workers' comp cases. That was a big change for us, especially for our staff attorneys who no longer had to summarize the workers' comp cases. Another big change was of course, the new courthouse. It's not new anymore, but a much larger facility. And of course, for the advocates, now you can park immediately outside rather than hunt for a parking space when you have oral argument at the old courthouse, which makes a big difference, especially during the legislative session. Also, our multi-purpose rooms are used by attorneys all the time as well, which makes a big benefit to the public as well. With the creation of the 6th DCA, we lost 2 of our judges to the 5th DCA. And we also lost our largest circuit, the 4th Circuit, to the 5th DCA as well, which is basically the Jacksonville. And I think those are most of our big changes. Oh, when I was appointed to the court as well, we only traveled to Orlando for the WCI Institute, where we heard workers' comp appeals, Jacksonville, and Lake City. But since then, we have traveled to, I currently travel to Milton, Fort Walton Beach, and Crestview in the 1st Circuit. And on the 2nd Circuit, besides hearing OA cases here at the courthouse, we also sit over at FSU. And we also sat in Apalachicola as well from time to time. And in the 3rd Circuit, we've sat in Mayo, Live Oak, Madison. In the 4th Circuit, before it was transferred to the appeals that was transferred to the 5th DCA, we sat in Virginia Beach as well, and Green Cove Springs. In the 8th Circuit, we sat at the University of Florida, as well as the courthouse there in Gainesville. On the 14th Circuit, we sat in Panama City, and Mariana. And for workers' comp appeals, we've sat in Miami before as well, since we have statewide jurisdiction over workers' comp appeals. And those are basically the major changes I've seen since I've been on the court.
Thank you. Judge Roberts and Judge Ray, this next question is for both of you. What has being on the bench been like in terms of, did it live up to your expectations when you applied versus the reality of what you've experienced over the last several years?
Yeah, I believe so. For the most part, I think I knew what I was getting myself in for. But you know, it's been a great experience. It is totally different from the practice of law in that, you know, as a lawyer, you're interacting with people on a regular basis. As a judge, you have colleagues on your panel, but typically you are in your office reading briefs and writing. So there's a lot of that. I didn't have to wear reading glasses before I started this job, and I've had to upgrade them at least twice since I've been doing this. But it's a great job. I have great, smart colleagues, and it's you know, I would recommend it to anybody that wants to have an intense experience in the law.
I was going to ask how many of you wear readers at this point.
Yeah, I wear contacts and readers, and have colored my gray because I do think you get that. Yeah, so it's exceeded my expectations. One of the things I didn't fully appreciate until I got on the court was how much we work together on cases, even when we're not on the same panel, we're not assigned to the same panel. And I think that's partly because we are an in-person court. Our culture here is that, for the most part, we're showing up for work every day. We're working in our offices, and that just lends itself to when I've got a thorny workers' comp problem, I'll just walk down to Kim's office and I'll brainstorm with her. If I've got those, you know, contested, you know, high-profile elections law cases, I'm going to walk down to Clay and I'm going to brainstorm with him. And we've got, you know, experts in criminal law and administrative law. So it's so nice to have those opportunities to brainstorm with your colleagues, separate and apart from, of course, your colleagues that you're on the panel with. So I really appreciate that. Probably the hardest thing that I didn't fully anticipate was the burden that comes with being a judge. I mean, when you're a private practitioner, there's a lot of burden, there's a lot of stress, and you're working hard for your clients, and you're always on call. There's a different type of burden when you're a judge, and it's the kind of burden that it's hard to turn off at night because every case is so important for different reasons to different people, and getting that right, recognizing that we are the court of last resort for most cases. So just the heavy burden that comes with being in a judicial capacity is something that I think we all take very seriously and are mindful of that awesome responsibility that we've been given.
I think that's very insightful. And even as a JCC, I think going from practicing to the judge, I would agree with that. Yeah. It's a burden. So Judge Thomas and Judge Nordby, being the newer judges from this panel, can you both talk a little bit about your experience and transition from litigation writing versus appellate writing and appellate opinion writing? Sorry.
I'll give it a shot first, Rachel. I think, interestingly, you know, in practice, you're doing the best you can with the time that you have. I mean, I remember, you know, 3 o'clock in the morning briefs, trying to get them finished so you could get them filed because you had a final hearing the next day. And so you're doing the best you can with the time that you have. What I have enjoyed immensely about being in this position is that I get to take a long time to study an issue, to research, to, you know, talk with my colleagues about it. You know, we have the luxury of time and digging down into a legal issue, and so I certainly enjoy that immensely. I find opinion writing much harder than when I was in private practice writing motions and briefs, etc., because as I've learned from my colleagues I've learned so much since I've been here and watched their different styles of writing, but every word that we write may have a meaning. A comma can change how a sentence is interpreted. one word can turn an interpretation or shift the outcome or how a case decision is perceived. So it's very difficult. I've never been I have sort of a journalistic background, so I can write you a short story in a second, but ask me to write a legal opinion, and it is a massive task in terms of, you have got to get everything just right. How can that be interpreted? Use the right words. Is it too broad? Is it too loose? Tighten this up. Do you really want to go that far? Because you don't want to tie yourself in. You need to stick to the issues on this case. So there's so many different things that we're looking at in our writing versus when you're preparing a brief. And so I think that's a lot different, but I found it certainly challenging, and I am continuing to learn and grow each day because my senior colleagues are kind enough we all come to each other's work. Get a read somebody and they'll say, you may want to think about saying this way, and I'll say, the lights went never that, yes, that's better. So it's a learning process every day.
How about you, Judge Nordby?
For me, it was intimidating. The transition, being a practitioner, briefs to sitting down and working on opinion, was intimidating. I remember very, very down, feeling the weight and the responsibility of isn't just another. This is going to become a decision of the court, not a decision of me personally, but it's going to go quarters as a decision of this court. So that was kind of unexpected. But at the time, the more opinion writing that I did, that kind of went away, and the joy of writing. As an appellate practitioner, I loved writing briefs. My favorite part of attorney, writing motions, being an advocate, and just really the power of words, and the editing process, and making your writing better through each draft and nitpicking over every word and sentence and paragraph. Time I got back to that, joy. The first, it was intimidating. Now, my approach to opinion, it's similar to when I was a practitioner. I want my writing to be clear, concise, understandable, and readable. That the party, public, my colleagues, whoever may be reading it, understanding what we as a court are holding and what the decision is. So.
Now, Judge Ray, Judge Lewis in his intro about the work comp division of the appellate of the First DCA. Can you tell us a little bit more about that? Like, how did that come about, and why is that so special for us? Why do we have that special?
Right. Well, because
section?
we're supposed, and I'm that, and I'm very proud of the fact that we have, as you all know, we have some jurisdiction appeals from the DC's orders. And because we have that exclusive jurisdiction, the legislature has given us money to fund a workers' comp unit where we have attorneys that expertise in the areas of law practice, and incredibly helpful to us as a court. I keep here at Sarah, senior, most experienced member of our workers' comp staff, and she's been with us such a valuable part of our team. And so the role of those attorneys are, when we get a work appeal, the clerk designated it as such, it goes straight to Sarah to preliminary matters, summary disposition, things of that nature. Ultimately, the lawyers on that will do the memo. So in regular merits cases, our clerks will do the memos. For work case done by the team, those summaries are done by attorneys that kind of understand the language of the workers' comp world. Trust me, when I came to the court, I had a running sheet of all the actions that are used into the language of workers' comp. And it took me a while to hang of those, but I have attorneys that know what PT, all those things are. And so they serve, basically, our law clerks for these workers' comp provide us the questions and the analysis. And it's come time to write opinion. Different judges rely on staff different levels to an extent, they may help draft decisions and things of that nature. But I'm just incredibly proud of our team, and that's therefore to support our work in this area.
Wonderful. Judge Roberts, can you tell us about three-panel
Sure.
selection? How assigned and when they assigned?
Okay, so our Ms. Samuels, who was the last panel, about a year out every year, she puts together the calendar, and she puts it together in a way where you sit with one of your colleagues at least once during the year, and you will sit with them twice, but she sets it up each of your colleagues more than twice. So every month you know who you're sitting with that month, and then they get random assigned to. So the first January panel, the first January comes in, you know, as they get perfected and they get assigned, and a judge in random is assigned to be primary in every case. So, and you decide which the primary judge will write, and unless the primary judge finds themselves in the dissent, and the remaining judge gets to decide who is in opinion. But it's a process that's time, and when we get as we get, we try to do what we can with them.
So is the primary typically the drafting judge?
The primary judge is almost always the drafting judge unless the primary judge finds himself in the dissent from the opinion.
Okay. And Judge Thomas, can you kind of on when the opinion is drafted, how process before the public?
Well, quickly, we'll go in and say if it's an open case, and whether it's the case of primary, I learned quickly, you know, I'm taking copious notes. We are in conference, and everybody's saying, you know, this is what I think about the case, this is important to me in my decision, and I'm taking copious notes, because if I'm primary and I write the opinion, I can cover issues that were important to colleagues, and that's important in my opinion process. So together my majority related to the least seen. We all three on a, I put the proposed opinion together. I send it to the least member of the panel second. That gets the decision, reads it, and either agrees or disagrees, or they may make changes or say it's a problem, and they may send line back to me. We may meet and tweak a little bit, and then satisfied, it goes to the third most senior judge on the panel, and it goes to the same process. Once it gets through people, it can be a long process because you change one, it's got to go back to the first judge and through the three. Once we get an that we've all agreed to on pre-release, and that is every judge in our court to see those opinions before they're published. They're on pre-release for one. I wish we had a little more because it's keep up with everything. So we have one court to look at opinions that are going to be released on Wednesday week. So I usually, of course, write workers' cases, or my knows definitely wants to get those, and so I can see a workers' comp opinion that's written by a panel I'm not on, and I can, you know, what the decision. So, you know, in fact, any of the judges on, if you're experienced in the specialty, if you question of the, or you know, this gives me concern, or I think this is misconstrued, any judge on the court can go to the panel, usually the primary, and say, can you talk about this opinion concern? Email them and say, with the panel about this decision. And wonderful about our collegial about that. It's not, you know, people aren't defensive of their work. It's a very good situation. I've never gone to anybody and had them say, too bad, Kim, I'm not going to pull that, or I'm not going to go down with you, you know, talk about that concern. The court is one in that respect. You essentially have 13 items. Every opinion that's despite three judges listed as the panel decisions.
So, and you on that, my next question, Judge Lewis, we haven't heard in a while. So. In that process, while there is a 3-judge panel that ultimately puts their name to that opinion, how much deference or input does one panel judge have in the ultimate outcome?
As previously noted, once the opinion goes on, it is emailed to the full court. Any non-judge can make recommendations to the primary judge or the author of the opinion, substantive or non-substantive changes. And it is within the discretion of that panel whether or not to make those changes. As my colleague noticed, we are collegial court, so we give serious consideration to such suggestions made by non-panel members, even though the panel is not bound by those recommendations.
Very nice. And then Judge Roberts, can you also talk a little bit about how you assess issues when maybe there's a prior opinion that potentially is different than what your interpretation of the statute is and what the opinion that you're about to release is?
Well, Comp's kind of unique because it is very